All right, welcome back. I will look to our court reporter. I know we just got into the room, but are you ready for us to go back on the record?
Yes, I'm ready when you are. Thank
Great.
you.
Thank you very much. And just to orient us, it is March 11th and the afternoon, and we have completed the evidentiary portion of the rebuttal portion of the hearing with respect to the proposed site's reservoir project. We are reconvening this afternoon to work through some procedural matters. One is the offer and acceptance of ITP-related and rebuttal exhibits into the evidentiary record, as well as noting objections orally, which then will be followed up with written confirmation, and we can set deadlines for those. My intent was to step through this and start with the authority, then DWR and state water contractors. After that, I thought we'd turn to Mr. King. And I think Mr. King, with that process, it may take a little bit longer because I will invite Mr. King, if he would like to orally respond to the objections raised so that he does not have to follow up in writing. That's up to him. And then we would work through the various coordinating NGO parties that are offering rebuttal exhibits. So that is my vision for the first part of our process. Are there any other questions or concerns before we start in on exhibits and numbers? Mr. Hitchings.
Yes, thank you. Just point of clarification. So after each party moves in their specific proposed evidence and testimony, then you'll seek objections after each party as to any of the evidence and testimony that is objected to, or did you want to save that to the end?
No, let's do it after each party. Thank you for
Okay.
that. Thank you.
Great. Thank you.
So I will turn first to the authority. I'm not sure if that's Mr. Ferguson. I saw you come off mute.
Yes.
If you, what I would like is if you would clarify first the ITP related exhibits. Well, you don't actually have to differentiate, but including both the ITP related exhibits as well as rebuttal exhibits, and then any cross exhibits that you're seeking to offer into the evidentiary record at this time. And my team and I, if you can just step through those, if you would also please note if there are corrected versions of testimony or exhibits so that we can make sure we have those corrected versions in our records. And we'll just step through this, not one by one, but
Okay.
as a block.
Yeah, so as a complete block, the authority offers sites 298 through sites 424 into evidence. And that's inclusive of any of these, the corrected or revised versions. And I can go ahead and identify for you what I believe are the corrected versions of the relevant exhibits.
That would be quite helpful. I see you also have them, looks like highlighted in your index, which is very nice. But if you would please step us through that, I would appreciate it.
Okay, so 306C, 308R, 311C, 316R, 334R,
And I believe that's it.
I
Is that
believe
right?
that's the complete list.
Okay.
Yes.
Thank you. So at this time, Mr. Ferguson, are you offering sites 298 through or revised versions, as you just indicated, for specific exhibits into the evidentiary record for this proceeding?
Ms. Kinsey, your audio cut out, and I think I know what you asked, but
What I meant was whether you're offering them. Yes.
Yes, sites is.
Thank you. Maybe I'll first I'm just confirming with, I think that fits on our end with what we have in our records. And with that, I will look to, I'll start with the coordinating NGO parties, and we can see how to work this out. I don't know if you have one representative or we can go through, but do you have objections to, and like I said, to be very summary, but are you objecting to any of the exhibits offered by sites? Elizabeth Mooney, thank you.
Yeah, I'll start off. I didn't hear the full number. Was this just the ITP sites, or was this also ITP exhibits, or was it just sites rebuttal? Or was
Everything.
it rebuttal? Everything.
Sites 298 through 424, which I believe
Okay.
includes the ITP evidence, rebuttal, and then cross exhibits used on rebuttal.
Okay. Well, I will start. I guess I'll start, and then
Great.
if any of my colleagues have anything to add. I just have a few that I think we'll be raising as written objections. And the first would be to sites 417, which is the written testimony of Jordan Navarrot. And in that, particularly with respect to paragraphs 8 and 9, I think that he was offered as a fact witness, and he was testifying to opinion as to future economic issues. And so I think there's a lack of, he was not offered as an expert. So,
Noted.
and then cites 381, Ms. Hale's written testimony, and probably more specifically, paragraphs 8, 9, 10, and 11, as to a lack of foundation for those, which some of that came out on cross. And I don't know how specific you want us to be in our oral objections, but with her, those would deal with the summary of authorities' wildlife surveys. And in her testimony, she could not really identify the dates that the surveys took place.
And Mr. Mooney, I apologize for interrupting, but no need to get into the details. You can put in your written memorialization.
Okay, that's fine.
You are foreclosing
okay.
nothing, but just to identify the particular
Okay.
exhibits in a very basic.
Yeah. Yep. I'm sorry, I'm talking over you. I apologize to the court reporter. So lack of foundation as well. And then cites 383, which is the wildlife species observed in the site's reservoir project study area during 2022 to 2024 surveys and monitoring. Again, lack of foundation. It's simply a list of species without saying where they are or where they were found, and so lack of foundation. And there's nothing else in the record to support that. So those were my three, and I don't know if Mr. Schutz or Mr. Boucher has any further objections.
Great. Thank you, Mr. Mooney. Mr. Busher, would you like to go next? Do you have any additional?
I don't have anything to add.
Thank you. Mr. Schutz?
Note for the record that Mr. Whittington's rebuttal testimony, and I don't have the number, could be considered not to be really rebuttal testimony because it was based on modeling done, or actually his ITP testimony, excuse me, was done prior to the issuance of the ITP. However, on balance, after discussion with my colleagues, it seems like there's value of leaving it in the record, and so we're not objecting.
Noted. Thank you, Mr. Schutz.
And that's all I have. Thank you.
So now my team is telling me I may have misspoke. So I'm going to go back to you, Mr. Ferguson. Did you offer was I correct that sites offered all of the exhibits, not just the ITP exhibits?
Yes, that is correct. 298 through 424, including the corrected and revised versions, covers both portions of the hearing.
Great. Thank you. We have that clearly now.
Yeah.
Thank you very much.
Right.
I will look to, are there other, before we move to the Delta parties, are there other tribal representatives or representatives of any of the NGOs who have objections to the site's exhibits offered? All right, then I will look to the Delta parties. Do I have either Ms. Meserve or Mr. Reese? Do you have objections to the site's exhibits? And I'll turn to you, Ms. Meserve, next.
No, I don't have objections.
Ms. Meserve, do you have any objections?
No, thank you.
Thank you. Mr. King, do you have objections to the site's exhibits?
No objections, thank you.
Thank you. Did I miss anyone? All right, then with that, the exhibits offered by sites are admitted into the evidentiary record with the exceptions and the caveat that we have outstanding objections to several of those exhibits. And we'll talk about receiving those in writing and then an opportunity for sites to respond. And then I will issue a final ruling with respect to those particular exhibits. The remainder are admitted into the evidentiary record. I will turn next to DWR. Do I have Mr. Soderlund here?
And I apologize for interrupting. I did receive an email from Mr. Soderlund earlier today indicating that he needed to jump off, and I suspect that he did not make it back on.
Right.
Unfortunately.
I see that. We can, what we'll do, hopefully he'll come back on at some point. But what we can do is, I'll come back to DWR, but if Mr. Soderlund appears and I forget, please feel free to jump on and remind me. And then I'll turn to you, Ms. Mundell-Rice, with respect to state water contractors. My understanding is state water contractors only had rebuttal exhibits, and that is SWC exhibits 1 through 4. Is that your intent to offer SWC 1 through 4 into the evidentiary record for this proceeding?
That is our intent. Thank you.
Thank you. And I will look to Mr. Busher, you're off mute. So do you have any objections to the exhibits?
I have no objection to 1 and 2. I don't recall what 3 and 4 were. I thought 1 was Mr. Goshi's testimony and 2 was the attached document. Were 3 and 4 cross-examination exhibits?
Yes, they were.
No objection here.
Thank you. Mr. Mooney.
I have none.
Mr. Schutz?
None, thank you.
Okay. And Mr. Reese?
No objections.
And Ms. Meserve? Thank you.
No, sorry. I was on mute.
Mr. King?
No objections.
Thank you. With that, then, state water contractors exhibits 1 through 4 are accepted into the evidentiary record. All right, I would at this time like to turn to you, Mr. King. I want to make sure that we have the right exhibits. My understanding is that your rebuttal exhibits are King 76 through King 95, including an anticipated corrected version of King 84, which is your written testimony, which will be coming. Is that correct?
I just sent King 84 to, it's King 84C.
Great.
It's based off the Word document that I previously submitted. So if your staff could, I believe it's the same document, but I apologize for that.
Thank you. And with that, would you like to offer King 76 through 95 with the corrected version of King 84 into the evidentiary record?
Yes, I would.
All right, thank you. And then I will turn to Mr. Ferguson. It looks like you're off mute. Do you have objections to the King exhibits?
It would be the same objections that Mr. Hitchings raised earlier today.
Okay.
With the addition that I believe sites will have the same objections to 84C as it raised for Exhibit 84 earlier today.
Noted.
So-
Mr. King, would you like to respond orally to those objections at this time, or would you prefer to submit brief responses in writing?
No, I like to thank you for the opportunity to orally respond.
Okay. Shall we, it's up to you. Do you want to start with your written testimony, King 84?
Yes, that's fine. They objected to two parts of it. The first part, pages 1 to 3, line 11, and the second part, pages 10 at 34 to the end. Regarding pages 10 to 34, at line 34 at the end of my testimony, I believe it is correct that I didn't cite any specific testimony. And to that extent, I do not have, any basis to refute that assertion that I didn't cite certain testimony, although I believe that the area origin issues were discussed by various parties and are very important, but I did not cite specific testimony. Regarding pages, so is that okay on?
That's fine.
Yeah.
Yep.
Then pages 1 to 3 to line 11. I would mention that my intent here was to provide the documentation for our water rights and the precedent of the previous State Water Resources Control Board decisions. Partly because in my case in chief testimony, you said that I didn't, assert any riparian rights, and there was issues about my water rights. So in some ways, it's rebuttal to some of the statements you made. You did make the statement that I could prove this in the rebuttal portion of that, and that was my intent, to be more complete and to completely, cite the relevant parts of the precedent that I perceive in this earliest State Water Resource Control Board decisions, but also to go over the basis for my riparian rights. And so that was my intent. And so my rebuttal is mostly in how the proceedings, the time limitations I had, the ineffective use of time that I had beginning into this, which impacted my ability to make the substantive claims that I intended to do regarding my water rights, and my not perfect understanding of what my case in chief testimony was. So I intended to use all that to rebut that, and I'd ask for your accommodation, given that it took me some time to actually use my case in chief time and the time that you allocated to me earlier to specifically around my water rights that I'm asserting.
Thank you, Mr. King.
Okay, so regarding and I want to thank the authority for sending me the written objections they had, and so I'll respond that in order that they mentioned earlier. They mentioned they're objecting to King 80. And I don't know if we want to bring that up, or should I just discuss that?
Let's go ahead. Ms. Mullen, if you would please bring up King 80. Then we can all see it.
So this is, as you can see, it's a scientific publication regarding hexavalent chromium sources and distributions of groundwater, and it's coming out of some researchers in Stanford University, and it documents the ubiquitous nature of chromium and hexavalent chromium in the Clusa and Yellow subbasins, which are tributary to the Clusa Basin drain, but
Thank you,
also,
Mr.
Yeah.
King. I think the objection was lack of foundation.
yeah. So my
Uh,
foundation is that I consider myself an expert regarding natural contaminants in the Clusa Basin, Clusa Subbasin. I have been
Well, and Mr.
Sure.
King, I mean, it looks to me you're offering a scientific journal article. It
Yeah.
seems to be something you obtained. I gather that the Environmental Science and Technology, is this a journal? Are you familiar with this? Do you know anything about this?
Yeah, it's a journal, and I purchased it on I think it was Springer or one of the
One of
sources I
those.
subscribe to. Yeah.
And it appears it's a 2018
Yes.
publication.
Yes. And coming from Stanford University and Geological Science Department.
Understood.
So
I think
then,
that's
go
all I need for King 80.
Okay.
Shall we
Okay.
turn to
King 82, please? This is another journal that's it's from the National Institute of Health. It was published in 2009, talking about it's the exotology of hexavalent chromium in freshwater fish. And the authors are out of Jackson State University, and also one of the institutes in India. And it talks about the potential harm to aquatic life and certain types of freshwater fish. I brought this article up with Dr. Dr. Greenberg's rebuttal testimony, and also introduced it there.
Thank you. Thank you, Mr. King.
Okay, so King 85, maybe we should turn to that, Ms. Mullen.
Great.
When you asked for proof of our water rights, I did not know at that point it was going to be a complete evidence, that it would be something I introduced in evidence, which I did today. So this is actually a lot line adjustment map that was filed with the uh, uh, County of Colusa. And it's now part of public record, which reflects a lot line adjustment for the sale of the almond acreage, which is directly west of our riparian acreage. So it doesn't have the full, the authority is correct that it doesn't have all the documents with it, which there's a deed that's associated with this. The parcel numbers may have changed once the Colusa County assessor actually has a chance to review all this, but this reflects the separation of the riparian property that was previously owned by T&M King Farms, and the intent to transfer, and I should correct from this morning, it's permit number 19932, to transfer that water right. I believe it's a 1982 date to this company K&M Farming, which bought it. So my intent was to just show the property that the permit 19932 would be transferred to after you determine its priority and its appropriate continuance of its appropriate rights.
And King 85 is not cited in your testimony, but well, first of all, is that correct?
It's not cited in my testimony. Again, I didn't, but it is cited in my, this written testimony regarding my water right. And I wasn't, when you asked for that, I didn't know that was going to be part of the evidentiary, kind of record. But it's cited in the written part of my test, of the written part of my explanation of these, regarding my water rights.
Understood, but I just want to make sure that your intent now is to offer this document into the evidentiary record. Is that
Yes.
right? Okay. Thank you. I think we can move to 88. Is that next?
Okay. Yeah, 88. Yes, that'd be good. Can we move to 88, please, Mr. Mullen? Yeah, so, and I believe they're only, and Mr. Sites Authority can object. I believe that's only pages 2 and 3. They're not objecting to page 1. Is that correct, Mr. Ferguson, Mr. Hitchens?
You got it. That's correct.
Okay, so pages 2 and 3, if you go down to page 2 and pop to page 2. So I wasn't so formal here, but you can see on top left, Sites Exhibit 16, excerpt, not exempt, but excerpt DWR Coosa Basin investigation. So this is an excerpt from King 16, which is already part of the record, I believe, pages 25 and 26. That's where that source of that is.
So it's not Sites Exhibit 16, but King Exhibit 16?
Correct.
Okay, thank you.
I just confirmed that. Yes, I believe that's right. Yep. It says King K1625 on that upper right. So I numbered the pages.
I see. Thank you.
Okay. And then King 89, please. This is the last document that I believe was objected to. Okay. So the objection here is it's illegible. I think, that could be a fair characterization of it, but it really is the same map. It's the 1868 California Surveyor's map that was part of both exhibits King 4 and King 10. So the difference is that I attempted to denote where the remaining parcels that are held by T&M King Farms that relate to our riparian rights are, and that's the yellow. And then I tried to highlight the swamp and overflow language I discussed this morning. But it really is the same map that is in King 4, which was was kind of the diversion points are highlighted in King 10. And then now I'm actually denoting the property retained and where it fits in what was considered the swamp and overflow lands from the 1868 surveyor.
Thank you, Mr. King. I'll turn to Mr. Hitchings. Do you maintain the objection, given the representation that this is a bad photocopy of an excerpt from King 4, with the addition, it sounds like, of this notation of T&M property?
I mean, it's very difficult to read. We now have, I guess, his testimony on it through his objection as to what it is. We can withdraw the objection on this.
All right. Thank you, Mr. Hitchings.
I do have a point to add. Mr. King did not cover the issue that we had indicated, to the extent that he's asserting that King 84C is admissible expert testimony. We did object that it's inadmissible expert testimony. He did not cover that, and we would say that that should be consistent with the hearing officer's ruling as to his direct case in chief testimony, where there was exclusion of certain paragraphs that did not qualify as expert opinion testimony. The other thing I will note is we intend to put this as part of our written objections. All of what we went through today, we'll have it in there, so the hearing officer and your staff will have that, and we'll cover that as well. But that was one of the other grounds for objection that Mr. King did not cover.
Thank you very much, Mr. Hitchings. I appreciate that. And so I'll turn to you, Mr. King. Do you want to briefly respond to the objection based on the offer of your written testimony as expert testimony?
Yeah, so I understand you excluded most of my testimony as in case of chief. I didn't really understand the basis for that. But I would say that I am the world's expert on my property and its ownership on the Colusa Basin Drain and Colusa Trough. But also, I would assert that when it comes to issues of water quality and the redox potential from contamination, for redox related contaminants of natural contaminants, I have been spending the last decade trying to highlight that in commentary with the Colusa Groundwater Authority, Yellow Groundwater Authority, the DWR, California Water Commission, the Delta Scientific organization, and then also State Water Resource Control Board. It's something that I believe I have expert, at least I'm an expert, I'm an advocate, and I believe I've obtained expert knowledge based on that advocacy part as a stakeholder, especially under the SGMA legislation.
Thank you, Mr. King.
Kinsey, just a point of clarity. I believe King 84 is going to be C2. There was an original corrected version that the AHO created yesterday, and there was a subsequent corrected version that Mr. King submitted this morning.
Does that mean it will be C3? Because then we will have a formatted.
No, that will be C2 is what I'm calling C2 is what was submitted this morning from Mr. King. We will need to make the same corrections that were previously made to the original King 84, like pull the sentences together. So it could be King 84 C3 after we make those additional changes.
Thank you. Thank you for that. And we'll make sure the exhibit index reflects these iterations of the document.
Ms. Kinsey, I should add that the inadmissible expert testimony objection, that's what also underlies our objections to King 80 and 82. He does not have the necessary expert qualifications with regard to those chemical constituents and hexavalent chromium. That was consistent with your ruling as to similar paragraphs in King 68 in his direct case in chief. And that's why we're arguing that there's not adequate expertise to lay the foundation for those exhibits, which are what might be an exhibit that a qualified expert would rely on to support their opinion. So I wanted to note that was the basis for why we were objecting to those two exhibits, 80 and 82, King.
Thank you. Noted. Mr. King, before we move to the admission with these objections noted, did you have anything else briefly to add?
I did bring up the issues of chromium with Dr. Huber and Miss Huber and Dr. Greenberg. It was part of that rebuttal questioning. So, but I understand their points based off of your exclusion previously.
Thank you, Mr. King. Then with that, we will. Well, I think I need to look to the room whether, if you would please just raise your hand whether Mr. Soderlund, Ms. Mendel-Rice, or Ms. Mitchell have any additional objections to Mr. King's offered exhibits. All right, then with that, King 76 through 95 with a corrected and formatted version of King 84 are conditionally accepted into the evidentiary record with the noted objections, which will be the subject of follow-up written objections and a ruling by the hearing officer. With that, I believe we can, I saw Mr. Soderlund and welcome, and it's, I'm glad you're here. I think we should go ahead and move to DWR's exhibits. And make an offer of those. My understanding is that we have DWR 5 through DWR 8, so 5, 6, 7, and 8. Do you intend to offer those exhibits into the evidentiary record?
I do. I think yes, so definitely DWR 5, Mr. Miller's testimony. I think DWR 6 is the ITP for the SWP as a attachment to that. This is a little bit of like mea culpa for the direct. I don't believe I asked Mr. Miller of whether his statement of qualifications were a true and correct copy. I'm not even sure it's necessary, but I'll just say it transparently. I'd like to offer it into evidence of what his expertise is, but I didn't ask him on direct. And then the last thing is I think is that DWR 8 is a report. I tried to cross-examine Mr. Burke on it. Didn't lay foundation for it, so happy for it to go in, but if South Delta wants to object, I'm also not going to push on it as well.
Okay, thank you, Mr. Sutherland.
Yeah.
Understood. So with that, sounds like we have an offer of 5, 6, 7, and 8, but we'll see if we get any objections. I'll turn first to Mr. Ferguson or Mr. Hitchings.
No objections.
I guess you would be, you're sorry. I'm going through the wrong list here. I will look to the NGO parties. I see Mr. Busher, Mr. Schutz, or Mr. Mooney. Do you have any objections to the DWR exhibits?
No.
No.
And no.
Thank you. And then Mr. Reese. Do you have objections?
Yeah, I think there's going to be, I'm going to reserve the right to object on the basis of lack of foundation of 5, 6, 7, and 8, but I'll have to make that argument in writing because I was not here last week and need to review it a little bit further, the transcript.
All right.
I may not, but I do want to reserve the ability to do so.
All right, noted. Thank you.
Thank you.
Miss Meserve, did you have any explicit objections?
No, thank you.
Thank you. And then Mr. King.
No objections.
Thank you. So it sounds like what we have is, at this point, I'm not accepting necessarily any of DWR's exhibits into the record because they're all subject 5, 6, 7, and 8. Yep. All subject to potential outstanding written objections from the South Delta water users. So we will return to that once I have ruled on any objection that Mr. Rees may file. But we have the offer. All right, I think at this point we will turn to the coordinating NGO parties. I have them written down alphabetically, so I'll plan to go roughly alphabetically, which means that you are up first, Mr. Schutz, with respect to CSPA.
If it's okay, I'll let Mr. Mooney move to those into evidence.
Great. Then I will. Oh, Mr. Reese, I'm sorry. You have a hand up.
Yeah, I'm sorry to, I didn't ask this of the NGO parties first. Would it be possible if I were able to go ahead of them? I have to actually jump on a something at 2 o'clock in federal court. It's going to take me about 15 minutes on a CMC, but if not, I understand. But I think mine might be pretty quick.
We have no objection.
Thank you, Mr. Mooney. I appreciate everyone's cooperation here. So let's go ahead, Mr. Reese. If we can.
Yes, thank
turn
you.
to you.
For SDWA exhibit numbers 81 through 88, which are Greg Wilson's rebuttal, supplemental case in chief and rebuttal testimony and related exhibits we are offering to, or requesting that those be moved into the evidentiary record.
Thank you, Mr. Reese.
Also for Mr. Burke, supplemental case in chief testimony and ITP testimony and rebuttal testimony is the topic, and that starts at 91 and continues through SCWA 94. And we're asking that those be moved into the record. And then just for Dr. Leinfelder Miles, we have SCWA 100, which was her written testimony, and SCWA 101, which was her CV. And then where I have a little bit of confusion as part of the response to the evidentiary ruling, we had STWA 104, which was my declaration in response to the ruling with and also the underlying SDWA 105, which was the underlying CVP documents, which were referred to in Mr. Lamalini's case in chief testimony. So I shouldn't say I have confusion, but just to the extent that those need to be moved into the record, I'm requesting that those be moved in. Where I do have some confusion, I guess, is with regard to the supplemental. There was supplemental water rights information that I submitted as well. And that I'm not sure that was supposed to be moved into the record. It was just in response to your evidentiary ruling, and that was provided timely.
Thank you, Mr. Reese. And that's a fair point. I think my intent was if you wanted to move that supplemental information into the evidentiary record, if it's appropriate as material in the evidentiary record, we should do that explicitly, and we can give them, I don't know if there are numbers there for it or not. But that's what I think makes sense here. Otherwise, it will be treated as essentially, a non-evidentiary policy statement, except to the extent that you're reflecting, I mean, to some extent, you may be reflecting records that are already within the State Water Board's records that, if appropriate, we could take official notice of, but it would be cleaner if we just move it into the evidentiary record.
Well, I will do so. Then I'll move to have that moved into the evidentiary record. I think it's maybe in part of SCWA 104 as part of a declaration, but I have to confess I'm not 100% sure, so I'll have to go back and check if there is different numbering and get back to you here shortly.
Okay, so let's do this, Mr. Reese, on the follow-up water rights information. Unless there's an objection or a proposal from the parties to do this another way, if you could follow up in writing with that offer, and I gather that the exhibits are not already numbered, but if you would number them with exhibit numbers and then essentially resubmit them.
Will do.
That would be great. And then we can move them over, and then I will accept written objections to those on the same timeline. We can talk about that. But how quickly do you think you could? I know this may be an unfair.
I can do it. I can do it this week.
Okay.
The week, yeah.
So we'll set an appropriate deadline for other parties to raise objections after. I mean, the parties have seen the documents, but to articulate any objections to accepting those into the record.
And I may have made this more complicated. They may be part of SCWA 104 in my declaration. I just don't recall offhand.
Fair enough. We have a lot of documents. Thank you, Mr. Reese. So at this time, are you seeking to offer, I think you articulated SDWA 81 through 88, 91 through 94, 100 through 101, and 104 to 105 into the evidentiary record?
Yes, I am.
And for my confirmation, were any of those, as you recall, corrected? I don't see any demarcation of corrected versions. These are all the original versions that we received as far as you.
Yeah, that's a great point. With regard to Mr. Burke and Mr. Wilson's testimony, it's my understanding there was some minor changes that were made on the record last week, but we do need to submit erratas to formally add those to the record, and we will do so this week.
Great, thank you. So the offer is made with the errata that have been noted on the record, but will be submitted in writing. with that, I will turn to Mr. Ferguson. Do you have any objection to SDWA's offer of exhibits?
We do. We have an objection to SDWA 91, paragraphs 25 through 29. On cross-examination of Mr. Burke, he acknowledged that he had no personal knowledge of the contents of those paragraphs. And then SDWA 94, and slide 8 specifically, Mr. Burke indicated that, so let me back up to the first one, sorry. We would have a hearsay objection on the first one that I mentioned.
Thank you.
And on the second one, with respect to SDWA 94 and slide 8, Mr. Burke, during his testimony, made some comments about what the irrigation, I think he said master, perhaps he meant water master, working on the Pescadero tract, had said. And so we're objecting to his comments during his direct testimony that relate to what that water master may have said with respect to Tom Paine Slough. And so that would be a hearsay objection as well.
Noted. Thank you. Are those the two exhibits? Yeah. Thank you. And then I will look to, I will call on you as a group, Mr. Soderlin, Ms. Mendel-Rice, or Ms. Mitchell. Please feel free, if you have any objections, to come off mute and let me know.
No objections for me.
Thank you. Then with that, the SDWA exhibits 81 through 88, 91 through 94, subject to the noted objections, which will be ruled upon, 100 to 101 and 104 to 105 are accepted into the evidentiary record. And I'm also noting here that there will be follow-up from Mr. Rees about an offer of additional exhibits possibly related to my request for information about water rates.
Thank you.
Thank you. And thank you, Mr. Rees. Good luck with when you have your case management conference, and hopefully you can join us
I think I'll be back in just
afterwards
a few minutes.
in time for our discussion. Yep. Thank you. Mr. King, please.
So I just want to mention that I don't know if it was clear about if we would have the opportunity to introduce our water rights memos into the record. But Catchell Dahy also submitted a proof of their water rights, and I don't believe they're here today. So I just want to mention that perhaps somebody should reach out to them and see if they want to introduce that to the record also.
Yeah. Thank you, Mr. King. And I was going to make that comment at the end of this process. Miss Rosenfield, I think is her last name. Wasn't sure whether those need to be submitted into evidence, and we are happy to communicate that back to her so that that can happen as appropriate.
Thank you. And thank you for this. I think what we can do is we'll set well, let's go ahead and do it. We'll set a deadline for Friday at the end of the day, Friday, for any offer of information, documents, or it wouldn't be testimony. That's the thing, is anything submitted that wasn't under oath would not be testimony. I don't think that would be appropriate. So we may, if that was intended, we might need a follow-up on that. But any underlying documents, if they're going to be considered as evidence, would need to be offered into the evidentiary record. So I'll set a deadline for Friday to receive any requests for that with respect to my request for supplemental information related to water rights.
Ms. Kinsey, can I clarify a point?
Please.
Related to your comment? Are you creating an opportunity for those that didn't submit that information by the 10th of February to now do so by this Friday? Or are you just offering an opportunity for folks to further clarify their intended response that was supposed to be submitted by the 10th of February?
Thank you. Thank you for that. And it's the latter. My intent is for parties to have the opportunity to clarify their intent to offer documents that were submitted by the deadline of February, if it was February 10th, that sounds about right. By the deadline, if the intent is to offer it into evidence, you may do so by informing the AHO by
Okay.
Friday, and because there may need to be exhibit numbers and things like that. But no, I'm not soliciting additional or inviting any additional documentation related to water rights. So thank you for that clarification. Okay. Then I think, Mr. Mooney, were you up next with respect to an offer of exhibits? I don't, was Mr. Mooney or Mr. Busher? I'm not sure.
I am.
Great.
So, and I guess we'll just go, we were starting with California Sport Fishing Protection Alliance.
I started there
And-
only because it was alphabetical. You can choose to do it another way if you'd like.
That's fine. That's fine with me. I'll start and then with some of these. So we would offer CSPA 101C, 102, 103, 104C, and then 105 and 106, which were both used on cross.
Thank you, Mr. Mooney. And then we'll take these one by one. I will turn to Mr. Ferguson. Do you have any objection to this offer of evidence?
We do. We object to C-Spot 102 and 103 on the grounds of relevance. And then we object to C-Spot 106 on the grounds of lacking foundation and authentication. Ms. Bozzoni indicated that she wasn't familiar with the document on cross-examination.
Thank you, Mr. Ferguson. And Mr. Soderlin, Ms. Mendel Rice, or Ms. Mitchell, please feel free to speak up if you have any objection, further objection. And with that, I will accept into the evidentiary record 101C, 102 and 103 with the outstanding objection noted, 104C, 105, C-Spot 105 and 106 with the noted evidentiary objection still outstanding. And those are conditionally accepted into the evidentiary record. Mr. Mooney, are you still up next? I
am.
I have FOR if we're going alphabetically.
Sure. And I kind of have these broken down by witness, and so we have FOR 303 to FOR 307, which was the testimony and exhibits of Bruner, and FOR 317 to 322, which was testimony of Easter. FOR 329 to 341, which was Marino, and FOR 344 to 361, which was Smallwood, and then 364C, and then 365 to 371, which was Buckley.
I'm just going to pause for a moment and look to my team to make sure that fits with what we had documented. Let's see.
And I appreciate that.
I'm just pulling up our index here. I see, because there were some exhibit numbers in there that were reserved and were not used, which is, I think this all fits together.
Yes. And I tried to double check that
Yes.
yesterday as well as today, but
I think that fits at least what I'm looking at here, so thank you for that. With that, I will look to Mr. Ferguson. Do you have objections to the identified FOR exhibits?
Yes, we object to FOR 304 and 305 for the same reasons, on the grounds of hearsay. And to the extent that those exhibits contain survey responses that Dr. Brunner testified to in her testimony, they're out-of-court statements, unsupported by other documentary evidence because she didn't offer the actual survey responses. And so they can't be used to support findings regarding the scope or quality of the authority's engagement with tribes. We object to FOR 317 and 318, which are Mr. Easter's testimony and summary presentation. To the extent he cites results from the RES model, these lack foundation and authentication. Mr. Easter testified that he has not offered the model into the record, and we would contend that the description he testified to in the framework document is insufficient for another expert to recreate the results that he was testifying to. And then excuse me a second. That's it. Thank you.
Thank you, Mr. Ferguson. And then I will look to Mr. Soderlund, Ms. Mendel-Rice, or Ms. Mitchell. Do you have any additional objections to the FOR exhibits? All right, then the identified FOR exhibits are accepted into the evidentiary record with the outstanding objections noted, and those will be ruled upon by the hearing officer. All right, Mr. Mooney.
The next we have would be Save California Salmon. And that would be Exhibit 91A and Exhibit 29. And I just want to make sure 91A is clarified. I think originally that may have had a number of 11, but it's my understanding it's been relabeled as 91. It was relabeled as 91A.
We did do that, yes. And I think, and the reason for that, just I'll note for the record, the reason for that is because there was already an SCS 11, I believe. And so now we have this one identified as 91A. So you were offering 91A and SCS 29.
Yes.
Thank you. Mr. Ferguson, do you have any objection?
We do have objection to SCS 91A paragraphs 24 through 26 as improper rebuttal testimony because he doesn't specify any previously submitted testimony that he's responding to.
Thank you. And then Mr. Soderlund, Ms. Mendel-Rice, or Ms. Mitchell? Hearing no objection, SCS 91A is accepted into the evidentiary record with the one outstanding objection, as well as SCS 29 is admitted. And then I believe, Mr. Mooney, I'll turn back to you for Water Climate Trust. Is that right?
Yes. And then this would be Mr. Asarian's testimony and exhibits for WCT 60C, 61 to 71, and 72C.
If you just give me a moment, I will also confirm that was our understanding here. Yes, that fits what we have as well. So with that offer of evidence, I will look to Mr. Ferguson. Do you have any objection?
No objections.
And I will look to Mr. Soderlin, Ms. Mendel Rice, or Ms. Mitchell, if you have any objections. Then hearing none, with that, WCT 60C, 61 through 71, and 72C are accepted into the evidentiary record. And I believe with that, I will turn to Mr. Busher for SF Baykeeper. Is that right?
Yes. So we would request and move into the record exhibits 127, 133, and 134, which were used on cross-examination. And then exhibits 128 to 132, which were Dr. Rosenfield's testimony in the 4 attached documents.
Thank you, Mr. Butcher. Mr. Ferguson, do you have any objection to those exhibits? And you're on mute.
We do have objection to 128, 129, and 130. These are voluminous documents and contain numerous hearsay statements and are not sufficient in and of themselves to support a finding by the board, unless they would otherwise be admissible over objection.
Thank you,
I would
Mr.
say too, CITES objects to the portions of these documents that are not otherwise specifically cited to and relied upon by Dr. Rosenfeld in his testimony, I believe paragraph 21.
All right, thank you.
Just for clarity in responding to those, are you objecting to the portion that is specifically cited, either in paragraph 21 or elsewhere?
No.
Okay, so if it was just those excerpts, there's no more objection?
Correct.
We'll take a look and respond accordingly. Thank you.
Thank you. Mr. Soderlin, Ms. Mendel Rice, or Ms. Mitchell, please feel free to speak up with any objections. Then with that, SF Baykeepers exhibits 127, 133, and 134, as well as 128 through 132 with the outstanding objections noted are admitted into the evidentiary record. Did I miss any exhibits? I think we got through everything. All right, I think it makes sense at this point to follow up on the evidentiary objections. I realize we have offers related to, if any, related to the information submitted. Well, let me do this. I'm going to put you all on the spot. Mr. Hitchings or Mr. Ferguson, do you have a proposal for one, a deadline for just a written documentation of exactly what was said today, essentially? I mean, you can fill it out slightly, but I still want it in summary format of evidentiary objections in the table format as you provided before. I would ask for it both in a PDF version and then also in a Word document so that the responding parties can include their responses in the Word document, and then the AHO can respond in the Word document as well. That's very helpful to me and I really appreciate it. But what would be your proposal as to an appropriate time to submit those objections in writing?
We can submit them by this Friday.
And then if that were the deadline, what would be your proposal with respect to responding in writing to any objections to the CITES documents?
I'd propose a week, so the following Friday.
Thank you. So I will look to Mr. Busher, you're off mute, so you'll be on the spot first. Do you have a different proposal, or what is your response to that?
In terms of submitting the written objections, I think this Friday is probably fine. I think we only raised 2 objections for sites to respond to. They raised several more than that. I think I probably asked for, at least 2 weeks instead of the 1. But I think Mr. Mooney is likely to be doing most of that work, so I'll defer to him.
Mr. Mooney, would you like to follow up?
I would prefer to have Monday to file the objections and then maybe 10 days for reply. Just debate. It's, there's not a lot there. It's just the amount of other deadlines and work trying to maintain.
I understand. Thank you, Mr. Mooney. Mr. Reese is, I'm not sure he's with us or not. Mr. Reese or Ms. Meserve, do you want to jump in? I was trying to flip back to see how many objections there are to the South Delta users anyway.
It looks like Ms. Meserve is not on, and Mr. Reese might be in his
Is
hearing.
probably on his other thing. Well, that's fine. So let me take a look at my inclination would be it would be fine to I guess let's just go ahead and do this. Monday is the due date for end of day, end of what I always call end of day. It's in the new world, it's midnight. It's not 5 p.m. Monday, end of day for written memorialization, if you will, of evidentiary objections. And then I will do math and figure out what roughly 10 days is from there. And I will memorialize that in writing. It should be 8, 9, it should be the following Wednesday, whatever that is, right? That would be 10. I can look right now. So Monday the 7th, Monday the 17th, St. Patrick's Day. And then March 26th for responses. And then I mentioned this, let's see what we get by end of day on Friday with respect to the water rights. If there are any additional offers of evidence into the record related to the water rights, and we'll see if we need to set corresponding deadlines to follow up for that. But let's see how that plays out on Friday. If there is an offer by the end of the day on Friday and any party wants to raise objections, please just you can summarily let me know, let the AHN know and the service list know, and then I will set appropriate deadlines for dealing with those. Unless you have a contrary suggestion, I propose we just see if there's an issue there. I think the next on my list is to talk about whether we need additional hearing days. But before we move to that, is there anything else related to evidence that we should talk about? Okay. Additional hearing days. Let me frame where I am at. I think long ago when we started this proceeding and we didn't have the ITP, there was some lack of clarity as to whether we'd have need a sur rebuttal portion because of the timing of when the ITP would actually be submitted. I left that door open. Because of the timing and the way that we received that information after case in chief, but before we got to this rebuttal portion, the protestants have had a chance to respond to the ITP, which wasn't clear when we started with this hearing. So I would be interested to hear from you whether you have whether any of the parties are seeking to offer additional evidence and what the basis for that would be, why you haven't yet had an opportunity to provide that evidence and what it would be responding to if there is such a request. The other piece of this that I want to put out there is that, as you know, this is a complicated proceeding. I think as the AHO and the division are working on drafting an order in this proceeding, we may have additional questions as we sort through all the evidence. So I would like to, even if we don't have a formal sur rebuttal, and I'm thinking we may not, because I'm not sure what else we would go over, but I would like to leave a wedge in the door, if you will, for evidence so that we could have, if on request, additional hearing days to hear from specific witnesses, if appropriate, to answer questions from the team who is working on drafting this order, whether it's from me or whether from some of our technical experts who may have maybe in a better situation to ask the type of technical questions we're dealing with here. So I did want to put that up. If we were to do that, I would, of course, give you notice as to the specific topics or specific questions. And then all of the parties would have an opportunity to participate in that and ask questions within the scope of what we're talking about. But I wanted to put that out there as a possibility because I think we may have questions that just haven't been sorted through at this point. So with all of those thoughts, Mr. Mooney, please.
I just had a question about what you had said. Are you talking about like that the hearing officer would essentially kind of recall a witness because you had specific questions for a specific witness? Or would it be that there would be an issue that would be presented, that you would say, here's our issue or here's the question, and that all the parties then would have the option of proposing or preparing a witness, or I shouldn't say prepare a witness, but have a witness testify to that issue?
What I was thinking when I said this was the former, that we're calling a specific witness to ask follow-up questions that may not have come to mind at the time. But as we're sorting through the testimony and the evidence, that there is follow-up.
So it would not be the additional written testimony that you would be asking for that would be submitted ahead of time, or would you ask for written testimony to be submitted ahead of time?
Well, and I don't want to foreclose. So one of the things that has crossed my mind, and whether we will have follow-up questions about, I'm not sure, is whether, for example, the updated calcium modeling, which I think has not been done, but is going to be done soon. I'm not sure what to do with that. I haven't thought it all through. But that's an example, right? Is that if there is additional information that becomes available, and in the perspective of the hearing team, it would be helpful for drafting an appropriate order, it may be something that we would ask for. And then that would be a situation where I think you'd end up with, it would be additional evidence, not just questions on questioning from the hearing officer. So I don't want to foreclose either. I just haven't thought it all through. I think you're probably in the same boat. I haven't digested and we haven't digested the rebuttal testimony fully at this point.
Well, and I'm glad you raised that, because that has been one of our kind of continuing concerns too, is that there's the CalSIMS 3 model that's supposed to be coming out, and we were going to raise that as part of this discussion today, as well as, they've indicated that they're working, the sites has indicated that it's been working on I think it's the unit cost, something we still haven't seen really. And we all think that is critical information to not only be within the hearing record and the evidentiary record, but also for briefing. So at least on behalf of my folks, I appreciate the consideration of being able to address those issues prior to the formal proceedings coming to a conclusion.
Thank you, Mr. Mooney. Mr. Busher.
Yeah, just a question in terms of thinking about how this is going to look, and what the calcium modeling or the financial analysis that's underway, whether that could be considered. I didn't know if you had an idea of when you would expect to have any additional testimony or witnesses come back to answer those questions, if that's 3 weeks from now or 10 weeks from now or something else, just in terms of trying to figure out what that could encompass.
Not 3 weeks from now. We'll be doing something else 3 weeks from now. Well, let me hear. I'll relay what I'm thinking, but you can't hold me to it. That's why I get the discretion on this one. But this is what I was thinking is that I actually am very interested in getting closing briefs. But if we were to have supplemental evidence come into the record, then of course you would have an opportunity to respond to that as well. But I think what we'll call closing briefs, if so it might be almost closing briefs, would be very helpful to the hearing team's ability to digest this information and sort through it and focus in on whether there are any remaining gaps or questions. So what I had been thinking was that we would set an appropriate schedule for closing briefs, but not yet close the evidentiary record, which I realize is not standard, but I think in this case, because of the complexity, it may make sense to do that. And if that were the case, then we would need an appropriate period of time to have you submit closing briefs. We would need to look at them and digest them, and then we would be talking about whether there was whether any additional hearing days were appropriate. But this, once again, I'm just thinking this through out loud as we're having this conversation. And I know you haven't had a chance yet, Mr. Hitchings, so please.
Yeah, that's the suggestion I was going to make. We don't know when the calcium modeling will be ready. It's uncertain at this point when that updated financial information will be available. In our view, there's adequate evidence that's been submitted for the board to make the determinations it needs to make on the application and the petitions. And we would object strongly to just having some kind of open-ended schedule. So we completely agree with the idea that set dates for closing briefs. And if a showing is made where it's necessary to have some additional information presented, then that can be addressed at that time. And just in all candor, I mean, from the site's authority perspective, you know, we would really urge and request that this schedule be set up so that the board itself could act on a proposed order by the end of August of this year. And we would want to set up the closing brief schedule and maybe in a time frame that allows for the interim steps that would occur to have the board be able to act by then. We recognize that is less than the time in the AHO statute as far as getting proposed orders out and then having the board act on the AHO's proposed order. But given the board's strategic plan, which identifies this hearing as a high priority item to complete, given the governor's executive order and its water resilience portfolio report that indicates the need to accelerate permitting of WISIP projects, given the fact that this has been considered a critical infrastructure project under SB 149. I'd also note that every year in delay of construction, right now our estimates that's approximately $180 million increase in construction costs. And also every delay that in the construction, you know, potentially that's a missed opportunity to store water, you know, in the event that a permit is granted in this case. So we're really hoping that we can set up a schedule to achieve that the board is in a position that it could act to decide whether to adopt, modify, or reject an order from your office by the end of August. So we were going to suggest that closing briefs be due, you know, approximately April 23rd, about 6 weeks from now, and that the AHO, your office we would urge your office and request to try to issue a draft proposed order within 8 weeks after that. That would be approximately June 18th. that parties would have a 2-week period to comment on a draft proposed order. That would be July 2nd. And that your office would be able to transmit an actual proposed order or decision to the board approximately 2 weeks after that on July 16th. And then that would leave, 6 weeks that it would be sitting over at the board for it to walk through its process. So I want to throw that out there, just that's really the schedule we're seeing. And we're kind of going back from the goal to have the board in a position to act on the order and decide on the permit and the petitions by the end of August. So I appreciate you hearing our position on that.
Thank you, Mr. Hitchings, and thank you for the specific dates. Who's first? Let's see.
Mr. King can go ahead.
Mr. King.
Yes, thank you. So I appreciate the urgency by Mr. Hitchings and the authority. And I for one believe that this project, you will find a way to approve this application because of the state priorities. But I think the conditions would matter a whole lot. And I believe the Calcim 3 model and the financial aspects, I think realistically, we're going to get those after a decision is made because it's a control of the authority before that's released. So therefore, if you do make any conditions to your order, I hope that you would incorporate the uncertainty around the Calcim 3 model and also the financial aspects of it, but also with perspective that the Water Commission is going to have to figure out how to allocate the funding under Prop 1 and now Prop 4, that if you are going to propose conditions, that if they decide to allocate that state-funded money, that those conditions could be used to informative for a good allocation of the state's resources towards this project. So I just think realistically, we should not expect anything out of the authority until after you make a decision regarding Calcim 3 or the financial aspects, which is, probably just the reality of this type of proceedings. But I would hope that you relieve room for that uncertainty if you decide to sort of approve it with conditions in the conditions that you may propose.
Thank you, Mr. King. Mr. Mooney.
My couple thoughts are I think that's Mr. Hitchings' proposed schedule's a bit accelerated, or given the size of the record, and also that we are still lacking information that even Ms. Kinsey, you had indicated that the board staff would like to be able to see in terms of the Calcim 3 modeling as well. And then for us, we've been asking for that updated financial information that we think is critical. And those are things that presumably the timing of getting those things out are within the control of the authority, the agency and they have the ability to move that forward, and they know we've been asking for that information for quite some time. So, we don't think that there should be a proposed decision or a recommendation until that information's provided. And so I don't know if we have specific dates for closing briefs, but I think we're looking at more like end of May. Mr. Boucher can correct me if I'm mistaken there, but I think we're looking more like May 30th. And then the other question I had is there going to be an opportunity to submit any kind of like a reply to the other parties closing briefs?
And if you did have that opportunity, Mr. Mooney, how much time would you propose that be scheduled? How much time after the submission of closing briefs?
For essentially like a reply brief?
Right, correct.
I would say 3 to 4 weeks. on that.
Mr. Busher, let's go to you next.
Thank you. So a couple thoughts on the schedule or the questions about scheduling. One, I don't think that moving at the pace that the statute describes constitutes delay, as Mr. Hitchings described it. And so, right, accelerating that ahead of what the statute requires seems unnecessary. And doing it according to the statute's requirements doesn't seem like delay. The second thing is, and Mr. Mooney raised some of this, but given the uncertainty in the costs, the modeling, how the Bay Delta plan update is or is not going to interact with sites, rushing forward to try to get this done as quickly as possible seems unwise and risks limiting the relevant factors and not providing the board ultimately with the best information to make its decision on. The third thing I'll say is, I appreciate that Mr. Hitchings' client's interest is in to start to divert water as quickly as possible. But whether that is a good thing or a benefit or a bad thing and a harm is hotly disputed in this matter. And so the fact that sites thinks diverting more water sooner is a benefit is not a reason to act more quickly when the contrary view is that diverting more water sooner will cause significant harms for that reason. And then the last thing I'll say is we are again in overlap with Delta Conveyance Project territory here. We currently have, give or take 10 hearing dates between end of March and end of April. More evidence due from DWR in May, more hearing dates in June, and case-in-chief evidence due in July. And Mr. Hitchings' schedule entirely overlaps with that process. I recognize there was a request, I think yesterday, from some public water agencies to change that schedule for the Delta Conveyance Project. We're not here to address that request or that project. But if the schedule's not going to change, dumping a closing brief on top of that schedule is unworkable. If the schedule is going to change, I think Mr. Mooney's suggestion is reasonable enough. That sometime at the end of May and maybe 30 days to respond is fast, but manageable given the size of the record here and the number of exhibits and days of testimony.
Thank you, Mr. Busher. And I'll just, in transparency, in talking about these schedules, it's, well, one, it has been the practice of the AHO to issue a draft ruling or decision or order, whatever the appropriate term is, before formally issuing a proposed decision or order for the board's consideration. I think it's a good practice because it weeds out technical errors in advance, and it allows the AHO to correct anything based on the record. It is not, at this point, it's not my intent to vary from that. My intent is to issue a draft, allow parties to comment on the draft, and then based on those comments, put together a proposed order that would then go to the board and be considered by the board. I think shortcutting that is actually not a short, it creates in some ways more challenges at the last minute and the risk that the board will be considering something that needs to be changed in any case. So that has been my intent. I will lay out, that has been my intent. It's been the practice of the AHO, and I think that would be appropriate here. This is more of a commentary, but I wish it were that quick to work. Some of you have worked with, but many of you probably have worked with boards. It's not as fast as working with a director or one person. So there is time that will inevitably be part of this process, although I am aware that it is a priority. This is a priority for the board, along with some of the other pending proceedings. My intent is not to issue a ruling on and I know, Mr. Hitchings, you have a hand up. My intent is not to issue a ruling right here and now in terms of setting a deadline for closing briefs, but I do intend to set a deadline. I think that's the path forward. We're going to set a deadline for closing, what we're calling closing briefs. I'd be inclined to allow a reply brief because I don't think it'll slow down the AHO in any way. We'll have the closing briefs. We have a lot of work to do on our end. It's not that we'll be sitting there awaiting your replies. That they will certainly be considered, but we will have plenty to do. So I'm considering those things. So that is where I am right at this moment. And with that, to you, Mr. Hitchings.
Yes, I just real quick on a point with regard to acting in accordance with the statute that Mr. Busher raised. It would still be in accordance with the statute. It's within 90 days of the close of the record or the submittal of the matter to the HO, and it's within 90 days from that. So we're still asking that the schedule be set so that it's in compliant with the statute, but it doesn't take it all the way up to the maximum deadlines that are set there. And then with regard to a reply brief, we don't necessarily think it's necessary. I think having the opportunity to comment on the proposed order serves a lot of that purpose. If your office and you believe that it wouldn't slow down the issuance of an order by waiting for reply briefs to come in, then we don't have a strong objection to that. But again, we're just trying to, and that would be a little bit of a departure of the practice. I think typically, I think it's just closing briefs and then comments on a draft order. That's been the practice in most of the hearing matters that I'm aware of that the AHO has conducted. So I guess we default to that, but as long as it doesn't slow things down, we would be okay with that step as well.
Thank you, Mr. Hitchings. You're right. I'm not aware of a situation where we've as a standard open-ended matter asked for or invited reply briefs. We've occasionally had supplemental briefing on specific issues, but it hasn't been the practice to allow reply briefs. I'm thinking through, given the complexity of this particular matter, whether it makes sense. Mr. Mooney.
I was just going to say, my discussion about deadlines too is I probably wasn't being sensitive enough as well about the other matters Mr. Boucher has spoken about in terms of the tunnels, Delta tunnels that I know a number of parties here are involved with. So just
thank you, Mr. Mooney. And I happen to be aware that Mr. Schutz, I believe, has a third proceeding which is pending this summer. So I'm aware of that as well. And the South Delta parties. Mr. Reese or Ms. Missouri, Mr. Reese, welcome back.
Thank you.
I don't know when you stepped back into the virtual room, so if you do want to recap, please let me know. But we were discussing, as you probably gathered, closing briefs and timing. Is there anything at this point that you'd like to add?
Was there a discussion of, or was there a discussion of whether or not there is a suggestion, or is anybody advocating, or do you have views on the need for SIR rebuttal, or we moved past that?
We haven't exactly moved past. What we came to the conclusion, well, I don't know if we came to a conclusion, that might be strong. I came to a conclusion that closing briefs would be helpful. So what I had indicated was that I wanted to keep the door open at this point for additional, potentially an additional hearing day or whatever is needed if the hearing team has questions with respect to the evidence in the record, so that there may be issues that come up. I had not heard an explicit request from any of the parties at this point for SIR rebuttal, strictly speaking. And my intent, though, was to schedule closing briefs with the caveat that after reviewing those briefs, the hearing team has additional evidentiary questions, we may have to schedule additional days. And then, of course, there would be an opportunity to follow up very concisely based on that. But that's where, does that clarify somewhat?
Yeah, yes, it does. And I appreciate that. And from what I did here, I would just say that I think closing briefs anytime prior to, the middle of May is too soon. It's a large record. There's been a large number of hearing days and there's a lot of exhibits. And I also heard some discussion about reply briefs or that option and not necessarily being standard, but I would just say that, once the draft order is prepared, then it really becomes an issue before the board and it doesn't typically change much. Given the complexity in this case, it seems like a reply brief option would allow the hearing team to make any revisions that gets caught or gets pointed out that's necessary through the various closing briefs. And I think that would be probably an efficient approach. And I think, within 30 days or of the closing brief seems like a reasonable time frame.
Mhm. Thank you. So my intent at this point would be to consider our discussion today and issue a ruling on it as soon as possible, understanding that you need to know what the deadlines are, but I would say expect no later than the end of the very end of May to have initial closing briefs due. So put that out there, and then, but I will consider what the schedule might look like around that if we are going to have reply and how that relates to the other matters that are pending before the AHO and that many of you are parties to. But I think it's time. Do expect that you should be working on those closing briefs. I think I will have a ruling out. My goal would be by the end of next week, if not sooner, setting out that schedule. Mr. Schutz, please.
Thank you. I heard several different sort of iterations of how modeling and cost information might interact with the briefing schedule. And one option I heard was the potential for briefing to occur and then subsequent presentation of modeling and or cost information, and then some potential process after that with perhaps the potential for supplemental briefing. It seems to me really important to have these key elements somehow in the record, and to have the opportunity to digest them, probably to ask questions about them, and to use those as the basis of briefing at some point. So as you're considering, I understand the desire to get, I understand the desire to get, to keep the process moving, and the desire for, to avoid undefined delay. On the other hand, as you're putting together your proposed process, it seems really important to get this information. And I understand that there's technical concerns and problems with presenting the modeling information in particular, and trying to read between the lines. It seems like things are not going as well as they might on the part of the Sites Authority, and I'm sensitive to that. But it is within their control ultimately, and it would be, I think it would be an incomplete record if we didn't have modeling that included the ITP and some of the things that were promised or were suggested as missing by the modelers in both the ITP and the rebuttal phases of this proceeding. And the same goes for the cost. I won't go into some of the different things that have been said about the cost, but from our perspective, it seems really important as part of the public interest consideration. And it's not something, with all due respect to Mr. King, that in my view, one can sort of massage after the fact. It's directly part of the public interest consideration. So I hope that you'll consider this potential sequencing as you're considering your schedule. Thank you.
Thank you, Mr. Schutz. From that, what occurs to me is that would make sense is with what we're calling closing briefs, for lack of a better term, with the closing briefs, that would be an appropriate time for parties to indicate whether they're making an explicit request or I don't know how we phrase it, a request for supplemental information or opportunity for, it would be a request for supplemental information, I think, from the authority, it sounds like, or supplemental, right? Because the authority would have to do it if it's modeling. And that could be part of that briefing, and then there would be an opportunity with the reply, there'd be an opportunity to respond. And we could roll those things together. This would also give the AHO time to look at, as we're getting started, to look at what we have and see if there's any informational, what the hearing team sees in an informational gap or follow-up questions that we have. And we could go from there. That's what that's what I'm noting down as a possibility. Mr. Hitchings.
Yes, just real quickly, in response to Mr. Schutz. I'm not sure what lines he's reading between as far as things may not be going well for sites, but that's not what is driving the schedule or our proposal for the schedule. I think I set forth in detail our rationale for that. I would also say that with regard to the financial information or even whether the calcium 3 modeling or other modeling is available, ultimately, we're the one applying for the permit and then the petition for assignment and release. If the information is that the board, well, first, I guess in your instance, you and your office don't believe is there based upon the record before it, then we bear the risk that maybe there would be a decision not to issue a permit or to grant the petitions. So we're the ones that are operating with the potential risk with the deficiency of information if that is ultimately determined to be the case by you or the board. And with regard to whether any of our experts, I don't believe any of our experts that were testifying as to the modeling information qualified their opinions based upon that they needed calcium 3 modeling in order to affirm their conclusions. So to the extent that there was a suggestion that that was necessary information with regard to the testimony that's been provided, I don't believe that that's what's been testified to. Thank you.
Thank you, Mr. Hitchings. Mr. King.
Yes, so first of all, I want to kind of pull back I probably jumped the gun by going first, but I want to support Mr. Schutz and the other NGO parties. And since it is immaterial and resources in the control of the of sites authority, they should be have the incentive to provide that for the full consideration of the facts. But regarding calcium 3, I don't believe that calcium 2 has any modeling for the Coosa Basin drain flows. And I think there was a representation that calcium 3 was going to include that. I may be wrong, but it's been over and over clear to me that calcium 2 doesn't provide any information about the Coosa Basin drain flows, especially with the changes to the Coosa Basin drain in the last 20 years, and it's been dated material. So, for example, it didn't have any information regarding the flows with the current dams in the Davis Weir. I brought that up specifically. So, I don't know how you can assess the impact on the area of origin concerns for the lower part of Coosa County, or the water quality concerns, and how that might tie into the ITP without having good modeling for at least that portion.
Thank you, Mr. King. Mr. Schutz.
I'll be brief. I don't want to get into a back and forth with Mr. Hitchings, but to clarify the source of my earlier statement, Ms. Forsyth indicated that the modeling, the calcium modeling, during her testimony and on rebuttal and her examination, that the modeling on rebuttaling was protracted on rebuttal was protracted and taking longer than she had hoped. And that's the line I was reading between. So I didn't mean to otherwise divine what all is going on with the authority. That's the specific reference that I was making.
Thank you, Mr. Schutz. Mr. Mooney.
I'll be very brief. Just your comment about like in our closing briefs, the request for supplemental information from sites with regards to either the modeling or the cost. My only concern is we're making that now. We're already been making that, and we have been making that, and so I'm concerned that we spend all the time writing the briefs, and then we have to make that request for information that we think should have been made available long ago or at part of the record. And then if that is available, we're just having to write briefs again, but as opposed to getting that information up front. And it would be nice to know if we had an estimate from sites as to the schedule for the completion for when the calcium 3 modeling would be available and the additional financial information. If we had an update from them, that would be good. It might help give us some more information about setting schedules right now.
Well, thank you, Mr. Mooney. I'll let Mr. Hitchings speak for himself, but I think I heard Mr. Hitchings say that he doesn't know at this point when the calcium 3 modeling would be completed. I did want to follow up with you, Mr. Mooney. Do you have closing briefs and reply? Would you like to provide any input on a requested length?
We've thought about that, and it's also an issue for the NGO parties and separate protestants of who's filing briefs or how many briefs how many briefs the NGO. I mean, I'm only writing one, but I know that there's the Pacific Coast fishermen. I think they intend to submit a brief. The tribal interest may want to submit a brief that is either a joint brief with others or a brief that is more focused on tribal interests that have been addressed. And then, Friends of the River and the folks that we're a part of here. But I've been kind of, please, Mr. Schutz or Mr. Busher jump in, but I've been thinking somewhere in the neighborhood of 40 to 50 pages for at least those parties that think they need to have a fairly comprehensive brief covering all of the hearing issues or most of the hearing issues. I know that there's, again, some parties that might want to focus on more specific hearing issues, and I would suspect that they would have briefs of the shorter pages, fewer pages, not shorter pages.
Right. It is a puzzle how to set that up, but I'll figure that. I wanted to at least get an initial thought from you. Mr. Hitchings, please.
Yeah, I would suggest on that maybe you should direct the parties to meet and confer and provide you with a joint proposal. And if they're unable to reach a joint proposal, to provide you their positions and maybe set a deadline to do that. I think that might be a more efficient way to address it, and we might be able to resolve the issues at least amongst ourselves. And if we can't, then you'll have the positions in front of you.
That would be helpful. I appreciate that. in some ways, I'd be inclined to open it up to include a briefing schedule, at least as a matter of discussion in your meet and confer, not only page length, and allocation to different parties, but also a specific schedule. So
I would suggest on that given what we've heard today, that I think you're just going to hear different positions on that. I don't think there's going to be a meeting of the minds on that, and I think it's probably better for you to just put your schedule out there, because I don't know how much more different positions you'll hear, but I don't see us being able to find common ground on that.
understood. I think, I think as I already indicated, and at the latest end of May for initial closing briefs, is out there. If in this meet and confer with respect to length, you have a meeting of the minds, you can bring it to me. We can proceed that way. Timing in terms of a meet and confer, from your perspective, Mr. Hitchings, what do you think would be appropriate?
Well, I would suggest that maybe we meet and confer. We're all getting, it looks like we're getting a hearing day back tomorrow. But maybe we've already planned for that. But maybe the parties can meet and confer in advance of providing you either a joint proposal or other separate proposals by the end of next week.
I'm sorry. Meet and confer and submit something by the 21st was your suggestion?
Yes.
That's fine with me.
And we're talking about meeting and conferring on like the page lengths on briefs. How many briefs are being filed? Is that what you're?
That's my understanding. Mr. Hitchings, does that fit your proposal?
Yes, correct.
Yes.
Okay. Yeah, because that involves not just, there's some parties here, there's some parties in the proceedings that are not here and I think that's a good idea, because I'm a little reluctant to speak on behalf of people I don't represent.
Good move.
Good, then let's do that. The directive is for the parties to meet and confer. I understand, I mean, as many of you as you can bring together, I understand there may be, there are a number of parties to this proceeding, not all of whom are represented here or who may be available to meet and confer. But if those of us who are on the call here can meet and confer and then submit either a joint proposal, or what I would like is actually a joint one document that identifies what has been agreed upon and then any areas of disagreement. And then I will issue a ruling as efficiently as possible after that, so that you have a good sense of you know how many pages of briefing you'll be submitting. And then as part of that, with closing briefs, I would any ruling on length, I'll lay out in more detail what I would envision as how we go forward. But I suspect what's going to happen is that I want to see the closing briefs and our hearing team have a chance to digest the evidence a little further than we have sitting here today. And then we'll lay out how we would go forward. I had at least one other small item, but is there anything else we should talk about now in terms of closing briefs, requests for additional hearing days or evidence or information, that type of issue?
Well, it seems to me like we've kind of put a pin in the Sir rebuttal that nobody's offering nobody's proposing Sir rebuttal at this point in time.
I think that's right. Yep. So there will not be what we would formally call Sir rebuttal.
Okay.
So one thing I would flag in terms of additional hearing days, I don't know if this is necessary, but depending on what parties say in terms of evidence related to the request about water rights that the hearing officer made on Friday. I don't know if that potentially requires additional days of testimony or not. That may be one thing in the near term.
Noted. I mean, and I've thought of that too. That's why I thought, well, let's see what we get as of Friday. And then we can deal with that along with numerous other issues, but let's see if it's an issue. The one other.
Just
Go ahead,
just
Mr.
maybe
Higgins.
on that, hearing officer Kenzie, my understanding, and I think you clarified this with Mr. Ferguson, was that it's really for the parties to advise the AHO whether they want to move what they've already submitted into evidence. It's not to supplement, it's not to change, it's just what was submitted by the February 18th deadline. Are they requesting that it be considered to be moved into evidence?
That is
That's what
correct.
we'll get by Friday.
Yes.
Okay, thank you.
And I apologize, this may be an ignorant question since that request did not apply to Baykeeper. I mean, was your intent to have that information be submitted into the evidentiary record in terms of when the request was made? Because I'm not sure just how that is considered, how it is helpful to you if it is or is not part of the evidentiary record.
Well, one of the things, and I'm not sure, I didn't have an explicit intent because I really left it up to the parties to decide whether they needed it to support their case. Part of the reason I asked was just to provide the opportunities for the parties to have an option, to clarify what their claims are. And that isn't necessarily evidence, that's more like argument. I mean, in some ways it's like a briefing that I'm claiming these, and then to offer supporting documents, which we didn't get a lot of, as I recall, from briefly reviewing it. I had thought the parties would offer documents into the evidentiary record, but that doesn't seem to be the case. So to the extent that there were just statements of claims, I think that can be considered in the way that a legal argument would be considered, without evidentiary value.
Thank you.
So I didn't have I knew I had questions, but I didn't have a strict sense of how that would work out.
Thank you. And like I said, we'll pass that along to the Council Day folks.
And I very much appreciate that. Thank you. The one other item I had is a request for all of the parties but particularly for the authority. As we've moved through this proceeding, we started with proposed permit terms. And I believe to some extent those have been supplemented and changed and amended, and it would be very helpful for me if you would please submit a consolidated list of proposed terms and conditions of approval. For the protesting parties, to the extent that you submitted proposed permit terms, and those may have changed based on rebuttal testimony, et cetera, as we've moved through this process. Any updates would also be very much appreciated, but I'm just looking for a consolidated, particularly from the authority, because I think some terms may have come in with different testimony. It'd be helpful to have them all in one place.
Kenzie, are you asking for that? Oh, sorry.
Go ahead.
Are you asking for that sooner than later? Not as part of a brief, but
yes, sooner. So this would be helpful. How much time do you need to put that together?
I would say a week.
Okay.
Monday.
Yeah, we could submit that on Monday.
Monday okay, great. Along with the written evidentiary objections, same deadline. And I very much appreciate that. And the same, as I said, the protesting parties, if it makes sense to do that, please do. It will be quite helpful us to consolidate those, but it may not be applicable. I don't have that off the top of my head.
And that's fine, but I'm not quite sure we could get that by Monday. I'll kind of defer to.
If we had the same
Schutz.
objection deadline for objections, if the deadline for submitting any modifications to permit terms, what was the date for the suggested objections from the protestants?
It's Monday.
Is Monday as well?
Well, I thought it was gonna be the response date that you were
The-
referring to, Mr.
Oh, the
Schuster.
response.
From
The
Monday.
response, right.
So you like until March 20, not the 21st.
That was 26.
March 26th to submit any updated permit terms?
Yes.
All right, we'll do March 26th for everyone, for the authority too, if you need more time. Obviously, if you're able to do it sooner, that's helpful. But March 26th.
Hearing Officer Kinsey, this is just to consolidate those permit terms that have been proposed to date. Not that, are you saying to present and propose wholly new permit terms that haven't been presented on case in chief or during rebuttal?
I was thinking about just consolidating the permit terms that have been proposed. I don't know what the protestants are thinking. I mean, I think it would be fair for the protestants, for example, to propose permit terms in their closing briefs, right? It's a legal argument to some extent. So I don't know that I want to foreclose that option if a party, but it would not be considered evidence, right? That this is where, at this point, the testimony supporting permit terms is in the record. Does that clarify?
Yes, thank you.
Okay. I don't know how clarifying that was, but I guess it's if the protestants want to submit on March 26 updated permit terms, I think that's fair enough. You could do that, but what I'm asking for is just a consolidated submission of what has been proposed to date. I'm going to pause and look to my team. I know we've been going for quite some time, but I think that's all I have. And what this would mean is that we'd be adjourning. We're not closing the evidentiary record formally at this time, but we'd be adjourning. We would be planning to move forward with closing briefs. And I will be hearing from you according to the various deadlines next week, ruling on evidentiary objections. I realize your closing briefs you will need to know what evidence is or is not in the record so that there is a time element there. But this is going to be a last call in terms of us being together to discuss these issues, although I am open, if necessary, to trying to put together another, what we might call a status conference or something to that effect, if we do need to, if it is more efficient for us to discuss in person anything that may come up. But with that, Mr. King, do you have a closing thought?
So, Paul, I apologize if I didn't catch it. What did you say about permit terms? Whether or not we can resubmit our permit terms, or could we, about a deadline for that? Is that passed, or are you allowing people to revise their permit terms?
You're welcome to revise proposed permit terms and conditions. What I was clarifying was that the evidence, this is not additional testimony or evidence.
Right.
But what I had explicitly been asking for, particularly from the authority, was a consolidated list of proposed permit terms because the authority's terms have developed somewhat over the course of this proceeding, and it would just be helpful for me to have it in one place. But I set a deadline of March 26 for parties, if appropriate, to submit a consolidated list of permit terms. If they haven't changed, then there's no need to do that.
Okay. And so that would not be in the final brief. It'd be separate. So you want March 26 if we want to reconsider our permits, suggested permit terms.
You can put them the only reason I said March, and I didn't mean to be confusing. I just said March 26 primarily for the authority to submit a consolidated list so that the AHO can get going and start thinking about those, because there have been changes. I don't want to foreclose the opportunity for any protestant or the authority to propose different terms in their closing briefs. You can do that, but March 26th was a request primarily from the authority and anyone else who thinks it would be helpful for the AHO to see a consolidated list.
Okay, thank you.
Thank you. Is there anything else that we need to discuss today?
Hearing Officer Kinsey, I would just like to recognize and thank you and your staff for conducting an efficient hearing up to this point. I think we might be able to all pat ourselves on the back for getting to this point, that we've completed the rebuttal phase. It's been a lot of hard work, and I just wanted to recognize and note that.
Thank you, Mr. Hitchings, and to some extent, I'm happy to share, but you stole my thunder. I did want to say, I know we've had many days hearing together, but I really wanted to appreciate everyone's the highest level of, in my opinion, of professionalism and a good amount of cooperation and getting the witnesses here and hearing from them and working together and working with me. And I very much appreciate this. And it's been a pleasure to work with all of you.
And we would join in Mr. Hitchens' comments as well.
Thank you.
One thing we can agree on.
Good.
We don't have to meet and confer about it.
Same for me. Thank you.
Thank you, Mr. King. Then with that, we are adjourned. I will be hearing from you in writing, and thank you so much. And we are off calendar for tomorrow. So you can take that off your calendar and enjoy your day. Thank you very much.
Thank you.
Thank you.
You.